As a candidate and then as governor-elect, Maura Healey created some lofty expectations when it came to how transparent she would be as governor. So far, at least, she's not delivering. Here's what she promised back in December on GBH's Boston Public Radio.
Will you confirm that you will not claim exemption from public records laws as governor, and will you support legislation that at least cuts back whatever exemptions the legislature and judiciary believe they have?
Yes and yes.
Oh, well, that takes care of that. Okay.
Maybe not, actually. A few weeks later, Healey walked that promise back, posting on the state website that her office will evaluate requests on a case-by-case basis, and saying, quote, records held by the office of the governor are not subject to the Massachusetts Public Records Law. The Healey administration still promises it'll be more transparent than its predecessors, but when journalists have tested that promise, the results haven't been encouraging. Her office denied the bulk of a Globe request for basic records while redacting other documents covering her first month as governor, according to Samantha Gross and Matt Stout, political reporters for the paper. Healey's office also refused a records request from freelance journalist Andrew Kammer. Andrew and Sam both join me now. Thank you for being here. Samantha, what did you and Matt Stout request from the Healey administration, and what did you get?
Yeah, so we requested kind of basic items for the month of January. We requested correspondences between the governor and staff, communicating on her behalf, and legislative leadership, which was the House Speaker and the Senate President. We requested her daily calendar, a log of her travel, and we also requested a log of her calls, either made from her office line or her cell phone. What we got back was a pretty heavily redacted version of her daily calendar that had about 50 events, with most of the information redacted out.
Andrew, you made a different type of request. What were you looking for, and how'd you make out?
I asked for emails and text messages from the Baker administration about police, and I got nothing. I was told that Healey has this policy of releasing records, but that it doesn't apply retroactively, so no past governors' records will be released by the Healey administration.
So when Healey's public records officer gave you the message that you just described, you went to the state's supervisor of public records, Monza Arthur, who's appointed by Secretary of State Bill Galvin. How'd you make out with her?
So the supervisor of public records has 10 business days to respond to an appeal, and often does take the full 10 days. But in this case, I got a response the next day that said that the supervisor of records won't intervene because the governor's office is totally exempt from the public records law under this old court decision called Lambert from 1997. And also cited an opinion of the Attorney General's office that the governor is exempt from the public records law. And that opinion was written in 2017 when Maura Healey was the Attorney General.
I want to step back just for a second and get you two to explain why the materials that you were requesting are of interest, not just to the press, but to members of the public. So Samantha, could you start off, and then Andrew will go to you. Why is the stuff that you and Matt tried to get stuff that we should be able to have access to?
Yeah, I mean, the day-to-day kind of proceedings of the governor's calendar helps people understand who she's meeting with, the priorities that she's elevating, in her first few months as governor. And it also allows people to hold her accountable to things that maybe she said on the campaign trail or has said, in her first couple weeks as governor, that, they'll be able to compare what she's actually doing versus what she says.
Andrew, how about the retroactive records that you were looking for?
Yeah, I mean, the same idea that you should be able to see who the governor's emailing and what he or she is saying. And in the case of the police emails, Charlie Baker, during his tenure, he's responding to this massive state police overtime scandal and other state police scandals. And he also signed in 2020 a huge police reform bill into law. And, it would be nice if the public could go and see, what he was saying in his emails. And, beyond just the subject of the police, I mean, Charlie Baker's responding to safety problems at the MBTA, to the housing crisis, drug overdose crisis. And, probably the biggest thing, would be the COVID response. And again, people should be able to see what's going on, with the governor when he's, not out in public.
Andrew, like Governor Baker, Governor Healy now says she is not bound by public records law under that Lambert decision that you mentioned, but that she'll consider any request she gets on a case-by-case basis. But she also says that she'll weigh, quote, any unique obligations of the governor's office as she does so. I spent some time poking around with the Wayback Machine yesterday trying to figure out if Governor Baker had used that language. I don't believe he did, right? That's a Healy innovation?
As far as I know, yeah, that's a Healy innovation. And I think this is just another way of saying that she's responding to things on a case-by-case basis rather than following the statute as written. I mean, just for people's context, the public records law has a number of exemptions like personal privacy, ongoing policymaking discussions, law enforcement investigations, building and cybersecurity, and a lot of other things. And what Healy is saying here is, well, the legislature created all these exemptions, but it's not good enough for me. So, whenever I don't want to release something, I can just come up with another reason because I'm the governor. And I think that's, wrong. I think that the governor should be subject to the same laws as the cities and towns and state agencies.
Yeah, it seemed to me like in using that language and putting that out there for any member of the public or the media who's going to be seeking public records, she was actually trying to create an additional buffer, as you said, that Governor Baker didn't. Samantha, the Healy administration also provided to you and your colleague Matt Stout what you two called a unique legal argument in their response. What was the legal argument that they advanced?
Yeah, it was kind of two-part. So with the calendar that was heavily redacted, they cited a public records exemption, Exemption N, which is the one that Andrew just mentioned, that has to do with public safety, or like building safety and cybersecurity. And so that typically exempts things like blueprints of buildings, building plans, like emergency kind of evacuation plans, things like that. So that was kind of interesting application of that exemption. On the other piece, they didn't cite a specific exemption that's in state law, but they basically said that allowing us access to her emails and calls would interfere with kind of her day-to-day, the way that she's able to operate as governor, basically interfere with her day-to-day schedule. So not exactly an exemption, but it was the reason that they gave us.
And if the answer is no here, forgive me for bringing it up, but did you ever run into anything along those lines, that rationale with the Baker administration?
I did not cover the Baker administration for as long as I came in kind of.
Forgive me, I should have, yeah.
But yeah, I mean, I think that people found, it difficult to still, request records from the Baker administration, given the, Massachusetts governor's kind of, they've been citing these exemptions since 1997 when this Supreme Judicial Court case decision was made.
Andrew Comer, how about you? Did you run into, when it comes to that new principle that Samantha just described, Governor Healy's office articulating, did you run into that in the Baker years, or is that also a Healy innovation?
I actually didn't really request records from the Baker administration very often partly because of this court decision. It just wasn't sort of a priority for me, knowing that the governor is just going to say that he is exempt. But in this case, I figured, given what Healy had said during the campaign and after she had been elected, but before taking office, I thought it was worth a shot just to see how she would respond.
I want to ask both of you, the Healy administration, starting with the governor, has made it a mantra that she's going to be more transparent than any governor before her. She has said it in some way, shape, or form. Her spokespeople have said it, as we just mentioned. I think we mentioned, it says it on this governor's office public records site. They'll be more transparent than any other administration. It sounds great. Is there any evidence at all that suggests she actually means it?
Yeah, I mean, I think it's hard to compare when, her predecessors have been kind of equally shut down when it comes to public records requests. I have found, in the first few weeks and months, some of the things I've requested I've gotten quickly when it comes to, communications that were kind of transmitted to the governor's office. I was able to get, not by means of public records requests, but by just simply asking her office for them. But I don't think we really know yet. I think it's still kind of left to be seen how quickly she's going to be responding to actual public records requests and things like this. If we request the same things next month, will it look different? I think that will probably give us our answer.
Andrew, what do you think? Do you see any reason to take that promise seriously?
Talk is cheap. I mean, I think maybe there could be marginal differences in how she responds to requests for information, but I think what she really needs to do is to tell the legislature that making the governor's office subject to the public records law is a priority, and that she wants to see a bill this session, and that she's, willing to sign it. And, until then, I think she needs to just follow the public records law as written and not claim that just because she's the governor, she can do whatever she wants. Until she's subject to the same laws that, the mayor or the, town manager or select board of, the municipality where you live, the same law that they have to follow, then I think, just saying she's transparent is meaningless.
One more question for you, Andrew. People know, I think, how to find Samantha's work. They probably know where to get the Globe, how to get the Globe. If people are interested in your coverage of this issue and other issues, how do they find your reporting?
I write a Substack newsletter. It's called The Mass Dump, and you can
I
find
love that name. It's so good.
It's andrewqmr.substack.com.
All right, Andrew Quamere, Samantha Gross, thank you both.
Thanks for having me.
Thank you. Thanks for having me.
And as we take a closer look at Governor Healey's political agenda over the coming weeks and months, we'd like to hear what you think. Do her priorities line up with the issues that are top of mind for you? What should she be focusing on in your view? You can let us know at gbh.org/Healey-agenda.